I'm going through 7 factors that you need to know about mediation as it applies to your personal injury lawsuit. This information could help you to decide if you think mediation is a good idea, or if it's mandatory, then it will give you some more information about what mediation is. I'm Natalie Gerry, the principal lawyer and founder with Gerry Law. I help injured people get the compensation they deserve for their injuries. Today, it's all about mediation. So mediation is an alternative way to resolve your personal injury case without going to trial. It's a process where both sides meet with a neutral third party called a mediator to try to settle the case. So I'm going to give hopefully simple breakdown of how mediation works, why it's helpful, and what to expect. So first of all, what is mediation? Mediation is, as I said, a meeting between you as the client, the injured party, the other party, so the defendant or their representative. If it's an insurance company or a business, it would be a representative, and a mediator. The mediator is neutral, so they don't take sides or make decisions, but they help both sides reach an agreement. It's a less formal process than court, but the goal is still serious, and it's to find a fair resolution to your case. So for example, if you slipped and fell at a store and you're seeking compensation for your injuries, the mediator helps you and the store's representative find common ground, like agreeing on how much they'll pay you for your medical expenses, and helps to resolve other issues so that hopefully you can resolve the file and close the litigation and come to an end where you are paid something for your injury and the file can then be closed. The second thing is to consider why mediation. So there are several advantages to mediation, and especially for personal injury cases. So 3 of these main advantages are the faster resolution. So trials can take years, but mediation can be scheduled much sooner. It also gives you the flexibility and control over the outcome and the scheduling, as opposed to having to adhere to the court schedule and to be subject to a binding decision at trial. The second factor is lower costs. So settling earlier saves on court and legal fees. The third reason might be for confidentiality purposes. So mediation discussions are private, unlike in a trial where everything becomes part of the public record. So this is something to consider that might be a good thing for you, or maybe you don't consider that to be an advantage, but it's something to know about mediation. The third point to know is about whether mediation is mandatory. So only in some areas of Ontario is mediation mandatory. Those areas are Toronto, Ottawa, Windsor, and a few other locations where mediation is mandatory for most civil cases under the mandatory mediation program. And mediation must occur in these jurisdictions within 180 days of filing a defense, unless the court orders otherwise. So even if mediation isn't mandatory, you and the other side can always agree to mediate voluntarily. The fourth thing to know is about how mediation works. So here's a brief overview of the process. So before mediation, there's the scheduling. You and the other side have to choose a date where the mediator is available and the parties are available, and you have to prepare for the mediation. So your lawyer will work to understand what your goals are. So your best case scenario, what you really ideally want, and what you might be entitled to if you went to trial on your very best day. If the judge bought all of what you wanted and gave you everything, what would that look like? You then need to think of what your bottom line is, so the minimum that you'd settle for. You need to think that through. You need to go through the strengths and weaknesses of your case to have a realistic outlook on what's going to happen. You also need to exchange documents, so it's important to share evidence like medical records, accident photos, or expert reports with the other side. So for example, if you were injured in a car accident, you might provide medical reports that would prove your injury and the repair bills for your vehicle. So during the mediation, there's an opening statement where both sides explain their position and what they want. Then there are private discussions, usually where the mediator may meet with each side privately to better understand their perspective and to go go through things. They might not want the other side to necessarily know about their position, but so the mediator has a better handle on both sides' situations so they can try to resolve things. Also, there is negotiation. So with the mediator's help, both sides work towards an agreement. The mediator might offer suggestions or point out strengths and weaknesses in the case. For example, the store's lawyer might say, "We believe the fall wasn't entirely our fault because of your footwear." And your lawyer might respond, "The store failed to clean up the spilled liquid, which was the main cause of the fall." So there's a disagreement in, who's most liable. And the mediator can help to come to a decision about that, or at least, have some agreement on some point. So after mediation, it's important to know that there could be a settlement. So if you reach an agreement, then both sides will sign what's called minutes of settlement, which makes the deal legally binding. If there is no agreement and the mediation doesn't work, then you will continue on with your lawsuit. So it will be just one of the steps in your lawsuit. However, mediation does usually help to narrow down the issues and maybe gives both sides a more realistic perspective of what is going on in the case and what the weaknesses are and the strengths, so it can still help with the litigation process even if it's not fully successful. The fifth thing to know is about where mediation takes place. So mediation can happen anywhere. It can be in person, it can be virtually, or even just over the phone. You might sit in the same room as the other side, or you might be in separate rooms with the mediator going back and forth. And if it's done virtually, then the mediator might put you in breakout rooms with you and your lawyer and might talk to you individually and go back and forth between the rooms, so you won't necessarily be with the defendant the whole time. So what happens if you don't settle? The sixth thing to know is that if no agreement is reached, the case moves forward and it can still possibly go to a trial. As I said, though, mediation is still helpful because it can clarify the issues and give both sides a chance to understand the other side's position. Offers made during the mediation are confidential and they cannot be used against you later in court. So if you make a lower offer to try to settle in mediation, but once you leave, you decide, that's not what I want to go with, you can always go back to your other position, so the higher position, when you go back to court and when you go to trial. The seventh thing to know is about mediation and whether it's legally binding. So if you settle, the agreement that's written up in the minutes of settlement and signed by the parties is legally binding. And sometimes that can be turned into a court order, which would make it enforceable. The one thing to know, though, if the mediator has strong feelings about one side or the other in terms of the case, in the mediation, they cannot give a binding ruling about what would happen. So it is not binding in that sense. It's more of a discussion, and only if the parties agree is it binding. So the key takeaways about mediation: it's a faster, private, and cost-effective way to look at trying to resolve your personal injury case. It gives you a chance to settle without going to trial, and it still protects your rights. So preparation with your lawyer, and I would always prepare my client for the mediation so that we're on the same page, knowing what your goals are, what the evidence is, what your bottom line is, what the risks are, and I would prepare you with all of that going into the mediation. By participating in mediation, you could save time, you could save money and stress, and also come out with a fair resolution. So it's something to definitely give thought to. And if you have other questions about it, I can be reached and I would be happy to speak with you about it.